Okay, welcome everyone. It's actually week 12, although we're actually devoting this tutorial as the week 11 tutorial. And tonight we have four groups that will be doing their group presentations. These are namely the Carpe Diem, the Blades, CGRO Lopez group. We also have the Phone Reticulio group as well as the Legally Blonde group. So we've got four groups doing their presentations tonight. This means that we need to make sure that each group that has been assigned to do their presentation does not go beyond the allocated time. And so each group can only have about 12.5 minutes. The other reason for this is that I have a class at about 7:15 tonight. So immediately right after this tutorial, I have another tutorial. And so we need to make sure that the presentations are done right on schedule. So there was a request from the Carpe Diem group for them to do the presentation first. So we're going to allow them to present first, and then we're going to have a group of Jazz Blades to do the next presentation after the Carpe Diem does their presentation. We then have the group of Lauren Phone, and then finally we have the Legally Blonde group doing their presentation. Would there be any questions before we proceed with the group presentations? Any questions? None? Okay. So I'm gonna give the floor to the Carpe Diem to do their presentation now.
I'm sorry to interrupt, Shantae, but your mic's still off.
Oh, you're gonna have to turn on your mics because I muted everyone.
Hello everyone, our group is called Carpe Diem. My name is Shantae and the other members of my group are Lisa, Trent and Clarissa. We are discussing Ms. Julia Johnson, a political journalist who made a request for information to Justice Minister Michael Keenan in response to an article published on the news website news.com.au on October 20th, 2016. The article examined an email sent between Ministers Keenan and Dutton in which they discussed an amendment to the Customs Prohibited Imports Regulations 1956. The amendment would include the insertion of a sunset clause that would see the ban of the importation of lever-action shotguns with a magazine capacity greater than 5 rounds be repealed after 12 months. Ms. Johnson feels that societal sensitivity in regards to firearm control in Australia has been largely evident since the Port Arthur massacre in April of 1996. That fateful event initiated the implementation of the National Firearms Agreement and the supporting firearm legislation in the Australian states. In consideration of Australia's stringent approach to firearm control and the general concern of the public, Ms. Johnson believes it is in the public's interest that other conversations like the previously mentioned email become available for public access. Ms. Johnson's request for information is inclusive of any form of communication between the executive officers concerning discussions of a sunset clause on the firearms ban. Ms. Johnson lodged her request for information to Minister Keenan in writing, citing Section 11 of the Freedom of Information Act 1982 to support her right to access the information. The request was directed by post to the Minister's primary office in Western Australia. Ms. Johnson received a letter from the offices of Minister Keenan 1 month later advising her that her request had been denied under Section 24 and Section 33AI of the FOI Act. Section 33AI provides that a document is an exempt document if disclosure of the document under this Act would or could reasonably be expected to cause damage to the security of the Commonwealth. In response to the denied request for information, Ms. Johnson requested a formal review of the Information Commissioner. The Information Commissioner upheld the preceding decision by Minister Keenan under Section 55K of the FOI Act. Subsection 1 articulates that after undertaking an IC review, the Information Commissioner must make a decision in writing, which affirms, varies, or sets aside the reviewable decision. Ms. Johnson has decided to further pursue her request to the Information Commissioner and has lodged an appeal of the decision in the Administrative Appeals Tribunal, citing the rights provided in Section 57A 1A of the FOI Act, being that an application may be made to the AAT to review a decision made under Section 55K of the FOI Act. I'll now pass over to Lisa and Clarissa, who will discuss the issues relating to administrative law.
Thank you, Chante. The main issue in this scenario is the denial of Ms. Johnson's request for information to the Minister Keenan in his position as the Minister for Justice and the Minister assisting the Prime Minister for counter-terrorism. The request was denied under Sections 24 and 33AI of the FOI Act, and these sections form the two parts of the issue. With respect to Section 24, it is necessary that a practical refusal right exists for the denial. This refusal right is stated in Section 24AA of the FOI Act, which states that the request would substantially and unreasonably detract the minister from the performance of their duties, and that an insufficient amount of information was provided for the minister to be able to identify the document or documents requested. Upon reviewing the request made by Ms. Johnson, it is important to note that the topic of request is clearly explained, and the broad nature of the request should not detract from the actioning of same. As such, it cannot be reasonably be determined that complying with the request would detract the minister from his duties.
With respect to Section 33AI, a request can be denied if it would or could reasonably be expected to cause damage to the security of the Commonwealth. The term security of the Commonwealth is defined in Section 4.5 of the FOI Act and includes matters and activities which would be subversive of or hostile to the interests of the Commonwealth. The nature of the documents requested by Ms. Johnson would provide transparency to the public of government discussions surrounding changes to policy, and as such would be in the public's interest. In consideration of this, it is unlikely that such a request could be considered subversive to the interests of the Commonwealth. The policy topic, being the regulation of firearms, does not detract from this understanding either. Consequently, we determined that there was enough information provided that the request would not reasonably cause harm to the Commonwealth, and the Minister and the Information Commissioner were in error when denying Ms. Johnson's request under these sections of the FOI Act. I'll now pass it to Trent, who will talk about the administrative law rules and principles.
Thank you.
You've already got through this, Trent. You'll love your for the group. Thank you.
Administrative law provides for the regulation of executive decision making. It allows the public an avenue to request a review of government agency decisions. In our scenario, Ms. Johnson is the member of the public asking for a review of the minister's denial of the request. The Freedom of Information Act is designed to allow the public to gain information from the government and its agencies, thereby increasing transparency, which is the main objective of the Act. The explanatory memorandum of the Freedom of Information Bill 1981 notes that the Freedom of Information Act is intended to give members of the public an enforceable right to access, subject to specified exceptions, to documents in the possession of departments other than parliamentary departments and of statutory authorities and other Commonwealth agencies, and to documents in the possession of ministers. As Ms. Johnson's request was made to a federal minister, she is therefore bound by the Commonwealth FOI Act. The release of the material requested is consistent with the aim of increasing transparency. All members of the public have an equal right to access government documents. It is not necessary to show any particular need or reason for accessing the documents, nor do they have to provide an explanation. Therefore, Ms. Johnson does not have to demonstrate a need for the information. The fact that she is a journalist working on an article should have no bearing on the decision. It is a legal right to access any government information that is not exempt under the FOI Act. A minister or agency derives no power to arbitrarily deny access to documents.
1 minute to go, Trent.
Yep. Even though the minister has denied access under an exemption in the Act, Ms. Johnson believes he has done so erroneously. If a request for information is denied, an applicant has the possibility of appealing to an independent tribunal. The resulting decision will be binding on the agency or minister. Ms. Johnson has asked the Information Commissioner to review the denial and has subsequently appealed the IC's decision to the AAT. The agency or minister bears the onus of proving that their decision is correct and justified. Ms. Johnson's appeal to the AAT, being a merit review, is warranted as her argument is based on the factual issues of the case, meaning it is a question of fact, not a question of law. Thank you, everybody, for listening to our presentation.
Thank you very much. Thank you. In terms of my comments, I see that the group is very well organized, and you have the PowerPoint slides to show that, as well as the way you presented the content of the presentation. So well done to the group in that sense. The only problem I see so far is that in terms of the articulation of the relevant rules, they're meant to be related to the factual background. And what instead happened was that there was a broad discussion of the purpose of the Freedom of Information Act, which did not really specifically address the questions that would have been raised in relation to the factual background, such as the reasons for the denial, particularly because it would impinge on the time of the minister, or two, because of concerns that it would actually raise national security issues. So in other words, if you talk about the relevant rules, those relevant rules should be related to the factual background. You don't just speak of the law in general, because otherwise, you know, it's not helpful. So that to me was just a concern. So I'm going to give the marks to the group later on. But in the meantime, I have one or two questions, unless there's anyone else in the class who may have a question for the group. None? Okay. Now, I'd like to again emphasize that when I interrupt the group and tell them about the time, it's not my goal is not really to be rude. I'm doing so because I don't want to put too much pressure on the succeeding groups who then would have limited time to do the presentation. I need to make sure that I'm a proper taskmaster and telling you, that your time is about to be up. So don't look at it as being rude. Now, so let me ask the first question here. My question is, why are we speaking of a possible review by the AAT and not by the courts? You said that this is a question of fact and not a question of law. Why isn't it a question of law? For example, if you talk about national security, isn't that a legal concept that should be defined by the courts?
In this instance, I think we're pretty sure that it is a merit review. Basically, Julia is her opinion differs, but she's not questioning the interpretation of these sections. She's just saying that they're wrong. She's saying that I'd quote a bit from the book. From the textbook, there's actually a quote that says that merit review is a battle over the last word. And I'd say that's kind of what's happening in this section. They've stated that her request is denied under these sections, and she wants that reviewed because, in her opinion, they're wrong. Okay, there's not a legal question as in like a error of law. It's a question of fact.
But isn't it possible that the Information Commissioner, in upholding the decision of the ministers involved, couldn't there have been an error of law in the interpretation of what constitutes national security? So it's not a factual question, but a legal question in that sense. And so, whether or not you look at it as a question of law or question of fact, the related question really is, in that sense, is the AAT, for example, given the authority to interpret the law? And in that case, if it does, what distinguishes the AAT from a court which also interprets the law? Did you see the two questions? So those are two questions that I have.
Yep. Yeah, I see where you're coming from with that, and it's something that would certainly have to be discussed and evaluated on when determining whether or not to go either way. In saying that, we're not saying that the AAT is determining what is the security of the Commonwealth. What is being questioned here is whether or not she has the right to access the documents.
Yeah, but that right is actually linked to the determination that there is a ground for the denial of the right on the basis of, as an exempt document, on the basis of a national security issue. And that was exactly my point. The question of what constitutes national security, is that a question of fact or is it a question of law? If the minister, for example, interprets national security in a distinct way from a very legal viewpoint, isn't that something that should be examined by the courts instead of the AAT? And when, for example, in this particular case, because it was brought before the AAT, when the AAT examines the concept of what constitutes national security, isn't that an interpretation of the law? And if it does that, isn't it intruding into, how different is the AAT then from a court when a court also interprets a question of law? So those were my two questions. What do you think?
I think that's quite a bit to consider.
That's all right. I know we were running out of time. So I just like you to consider the questions that I raised because they're pertinent to the individual research essay. So in other words, I'd like you to address the questions I raised because to me it's relevant in the sense that, why do they have to go to the AAT and not undertake a judicial review? So it's a broad question. And to me, that's one of the legal issues that need to be considered. If you were the lawyer for the applicant in this case, would you have advised a judicial review? And why an administrative review? Because in the end, if it involves a question of law, then the ultimate determination will have to be made by a court. Because even if the AAT does interpret the law, because it has to interpret the law, and it does not, its jurisdiction is not ousted by the mere fact that it has to interpret the law, because every administrative tribunal needs to interpret the law. The decision of the interpretation of the administrative tribunal in relation to question of law is not final and definitive. So in that case, why go through the process of having to seek a merits review if in the end, ultimately, it is in fact a question of law which should be resolved by the court. So I'm just flagging those two questions. So thank you very much. That was a very good presentation from the group. You were very well organized and you came very well prepared. So thank you very much. Thanks. I'd like to move now to the next group, which is the group of Jazz Blades. And I can't really pronounce the last name of SGRO. How do you pronounce that? And then the Lopez group. I give the floor to them now to do the presentation.
Can you guys hear me?
Yes, I hear you. Go ahead, please.
Hi everyone, my name is Jazz and my group mates are Aidan and Tara, and we're discussing the group topic of access to information with reference to the case Duncan Secretary, Department of Human Services, Freedom of Information 2016. Firstly, I'll pass the mic over to Aidan, who will discuss the factual background of the case.
The case in question revolves around Mr. Duncan's request for access to departmental records regarding allegations that various people had breached the APS Code of Conduct. The initial request began in 2011 when Mr. Ian Duncan, under Section 15 of the Freedom of Information Act, applied for access to documents from Centrelink. Centrelink chose to group the request as one and declined him access under the practical refusal provision found in Section 24 of the Act. It was met with further refusal under the same pretense when an application was made for an index of the request. Several applications followed with further refusals varying from practical refusal to variation disclosure under Section 55G. At this point, Mr. Duncan began seeking a review by the Information Commissioner. However, this too was refused on the basis of practical refusal. The following year in 2012, the Department of Human Services, under Section 22 of the Act, made a variation to the original decision, which saw Mr. Duncan with minimal and partial access to the requested documents. The records had either been heavily redacted due to the inclusion of exempt information or were withheld and found to be entirely exempt by the Act. 3 years later, in 2015, the Information Commissioner denied Mr. Duncan's application for a review under the same principles of practical refusal, and the matter was escalated onto the Administrative Appeals Tribunal by request of Mr. Duncan. His argument was based on the fact that he was never provided with full access to the documents, and therefore the variation of access denial pertinent to Section 55G was not applicable. I'll now pass over to Jazz
for the issues relating to admin law.
Just realised I was on mute, sorry. The prominent administrative law issue relating to the case at hand is determining whether or not the executive powers and the Freedom of Information refusal decision has encroached on Mr. Duncan's right to obtain information. Section 3 of the Freedom of Information Act 1982 notes that the object of the Act was allow, upon request, the Australian community access the information held by the Commonwealth. In this case, the government agency Centrelink. The Act is to facilitate and promote public access to information. Mr. Duncan placed the request for information which was subsequently refused on the grounds of practical refusal. For the purposes of Section 24 of the Act, practical refusal exists where the performance of the requested task would substantially and unreasonably interfere with the performance of the minister's functions. By this measure, Centrelink have indeed refused Mr. Duncan's request with reasonable grounds. Consideration of the Freedom of Information guidelines issued by the Australian Information Commissioner and case law suggests the contrary, however. Chew and Telstra Corporation Limited held that the refusal section 24 can only be upheld where the agency have done all that can be reasonably done in order to find the documents requested. Senior member Popple further noted in AP that poor record keeping or inadequate administrative procedure does not fulfil the requirements of practical refusal. This is further iterated by the FOI guidelines, which indicate that fulfilling requests may include the addition of temporary staff or measures. The request for documents given by Mr. Duncan was unreasonably denied by the government agency Centrelink. There was a failure by Centrelink to maintain good record keeping and administrative procedure, and the agency failed to do all that was reasonably necessary to find the relevant documents, moving the onus onto Mr. Duncan to exactly specify the requested documents. In addition, the complexity of the request was not adequately triaged and the appropriate measures were not put in place to fulfil the request. I'll now pass the mic to Tara, who will discuss the administrative law rules and principles.
Hi, can you all hear me?
Yep.
Yep. So the applicable rules and principles in this case are outlined in the current slide. Section 11, subsection 1 of the Freedom of Information Act 1982, or the FOI Act, legislates the legal right to access executive information with the exception of exempt documents. The following legal rules embody the principles of good administration, executive accountability, and administrative justice by giving individuals and corporations a legal right to executive information and a right of reply. These rules are